Testing 1 2. Testing 1 2. That is loud. What's up, everybody? This is Supreme Decisions. There we go. Got the echo bomb. What's up, everybody? This is Supreme Decisions. There we go. Got the echo bomb. All right. What's up, everybody? Supreme Decisions here. Tonight, I'm actually going to talk to you about what happens when you have an attorney and they do not do what you're asking them to do. And just the case of, because you have no idea the amount of people that I speak with on a daily basis that tell me, oh, I hired this guy, he didn't file any paperwork. I've actually had a young man who I helped him with his appeal, which he won, and his lawyer admitted to lying to him. Like, it was the craziest thing I had ever seen in my life. She admitted to lying to him. And the ramifications of is what can I do when that happens? Because generally when you hire a bar card member, most of us feel like there is nothing that can be done that we can kind of recoup, kind of redo, because this affects our actual lives. So today I want to talk to you about the malpractice insurance, because there has been a cap that's been put on many cases with this. There have been many attempts to actually circumvent this thing, because the process itself is one of those, what do you call it? It's just one of those things that most people have no idea what it is. Now, attorneys or law firms malpractice insurance, formerly called Legal Professional Liability Insurance, or LPL, or errors and omissions insurance for lawyers. Always remember that errors and omissions is designed to protect attorneys from, where is that? There we go. It's designed to protect attorneys and firms from financial losses stemming from mistakes or allegations of negligence in the course of legal representation. Now, when we're doing this, the one thing that we want to actually be cognizant of is how it affects us and what can we do to kind of circumvent this for the most part. So, what we're going to talk about next is what is covered by the insurance. Things such as professional negligence, such as missing filing deadlines. Now, this is one that's more common because I always tell you, piranha don't eat piranha. And most attorneys that you deal with, if you're paying less than $50,000, they're not on your team. I'm going to say that if you're paying them less than $50,000, they're not on your team. And understand, a $50,000 attorney is one that is working for $500 an hour. Why? Because every case requires 100 hours. Now, if you do the math on that, 50,000, 100, 500. Now, you're going to have the better lawyers that are $900, $1,200 an hour. If you can't afford them, don't worry about them, because those are not for you. However, they very seldom miss these types of things. And they actually follow through, because just like the defense attorneys that I've had on the podcast, one of them actually told you that he had never filed actually both of them told you they had never filed a detailed discovery prior to using the one that I sent them, the one they paid me for. And they're the ones that went to school because they wanted to see what the hype was about. And then you look at the fact that when they started using it, they became ostracized. Why? Because the stuff that I'm giving you is the actualities of what they have to produce. Why? By their own codes and their own laws and their own requirements. And again, piranha don't eat piranha, so they're not doing that. So these are one of the things that fall under professional negligence. 2, fail to know or apply law correctly. I often say this, and it gets to a point of redundancy because I've said it more often than not. Most of these attorneys, I actually had a dude, I literally gave you the story a little while ago, where the dude, he didn't know what res judicata means. And it's literally on the first page of definitions. It's literally there. They are not taught what law is. And they don't know what they're supposed to do when they're getting confronted with these types of things. So if they don't know or don't apply the law correctly, you have a ground for professional negligence. Now, here's the one that I speak to more often than not. Poor legal strategy or advice leading to client losses. That would be a conviction, or that would be you actually having to pay out more than you would want to. I'm going to say that again, more than you would want to, because again, not only do you have to be able to sell what it is, but you have to put together a strategy, which most of them don't, because again, 50,000 is that number. If you're not paying that, you're not getting that. So more often than not, professional negligence is the number one claim. And that's also because most of them don't understand the strategy of winning, because they are not winners. I'm going to say that again. Most of them don't understand the strategy of winning because they are not winners, which is why they're not charging $50,000 or more. Number 2 would be errors and omissions. Drafting mistakes in contracts, wills, or pleadings. This is where I speak about not knowing the language, not understanding the language of the court, not being able to apply. This is where I separated myself from most everybody that does this. Because not only have my father started me doing this when I was 11, 12 years old, I've been doing this literally 30 plus years. This isn't something that just done by happenstance. This is constant repetition, and this is life. This isn't something, how Deontay Wilder says, he doesn't play boxing. I don't play law. This is an everyday thing for me. This is a way of life. This is my lifestyle. So understanding, every day I'm reading, every day I'm researching, every day I'm doing this. I'm in the midst of fighting battles, going through and understanding different means of case law and understanding application of what I'm learning. Because at the same time, I'm transferring it on to you so you can actually have that understanding. And most people don't know it. Because you got to look at, there's a reason there's a separation. Those are different levels and classes. It's because those people are applying the law and they are earning the arrogance. Not all of them, but there is a good portion that's at the cream of the creme that are earning that status of being able to call themselves elite lawyers. And there's a reason, because they don't mess up the pleadings. They don't mess up contracts. Because minor mistakes, the verbiage, I constantly speak on that, is one of the most important things when you're doing anything in law, because the wording, how you say something, how it's interpreted, is how it is applied. That's why the separation comes in from everyone and myself. Now, failure to include important provisions. Now, this is more contractual, not necessarily courtroom. However, give you an example. Certain provisions are simply guidelines for, let's say, I was doing a contract, an employment agreement for a trucking company. Well, the same agreement can't be used for a restaurant. They can be similar, but they can't be the same, because there are different guidelines and different needs and requirements that's for the trucking company and another for the restaurant. So they're just like in the restaurant we had a social media provision. Trucking also had a social media provision. They're not going to look the same. They might look similar, they're not going to look the same. We also had a closing procedure. Trucking company had a similar closing procedure. However, it was similar, not the same, because I don't have to lock a gate, but I do have to lock a door. I don't have to secure a load, but I do have to make sure the refrigerator is closed. Things of that nature. Similar but not the same, but those provisions must be worded correctly because the provisions are what's going to be applied in court. Now, administrative mistakes. Now, here's something that happens when this is mostly with public defenders. And because none of them spend 100 hours on any case, like whatever. And most of them file the wrong documents. And this is also a case of when you're doing it pro se and you have no guidance. You file documents incorrectly. And just like when you should be, let's say you file a demur when you should be filing a motion to quash, or you file a demur when you're supposed to be filing a motion to dismiss. And again, while it seems small and insignificant, these are things that can be set up and actually ruin your case. Now, at the same time, you can go and do something to correct that mistake, but oftentimes you don't know how to correct that mistake, which makes it a horrible filing, which then becomes detrimental to your case. And these are the same things that you can hold your attorneys liable for. Now, number 3, breach of fiduciary duties. Mishandling conflicts of interest. Now, this is one that I actually use often against the police union. Why? Because you have an attorney that represents a police officer or multiple police officers, but they also represent the police department. Well, that's a horrible conflict of interest, not only for the officers, but also for the police department. Why? Because each officer may have a different role in the action, which also carries a different interest from the police department. So each one of those have separate interests in what's going on in the defense. So how can one attorney or one law firm cover that? Well, they can't. And because they try to do that without getting a conflict of waiver interest or sign, they are then liable. And I've actually helped a couple police officers after I sued them. Hey, go ahead and get you some money back because this fool never had you sign a conflict of interest waiver. And it's something I brought up. I put it in all the filings. If I'm suing multiple officers, I make them file that. Because that way, if you're going to have that one idiot represent you, he's going to pay for it. And if not, you're going to come out your pocket. So it's your choice. And a lot of times they choose to ride with the idiot. And then when they lose, they're upset. But again, I don't do this all the time, but it's often possible. Because, like I said, I have sued a few people that followed the wrong guide. Instead of following law because they didn't know it, they were following the instructions of those that were in supervisory positions, which put them in a bad position because I don't lose. A fool with a purpose. Always understand that. Okay, failing to disclose relevant information to the client. Now, this is where one of the things that I do often, because I call it expectation management. Anything that I have that comes up, I try to tell you maybe not what I'm filing or how I'm filing it, because sometimes too much information gives you information overload and it sends you further into a panic because most people go into flight instead of fight. I give you the information that's necessary to manage your expectations for what we are doing. And I'm going to say that again. It becomes with expectation management because it's failing to disclose the relevant information is what drives someone into extra things that is unnecessary. And just to give you an example, I have there's a preliminary hearing. I actually did a video. You're going to lose 99% of preliminary hearings. But that does not mean you don't file paperwork to set up the foundation. Does not mean that. So whenever I do that, most people are like, well, what I got to do? Well, you're probably going to lose this. And they become discouraged until they start seeing things happen that did not happen prior. And that's the break that most people get because, oh, well, they ruled against this motion. Cool. I actually had one, which is one of the funniest ones for me. The judge in the case, we filed an omnibus motion. When we filed this motion, the judge said, we do not accept omnibus motions. Then, technically, striking that motion. He then stated everything in that omnibus motion had to be delivered by the prosecution. So did we lose the motion? On the record, it's a lost motion, but the decision was based off of the omnibus motion that we lost. So while it seemed on paper that we had lost it, we got everything that we asked for in the motion. So a lot of times you have to pay attention to people's actions, not listening to what they're actually saying, because it's the show, not the show. And last, acting against the client's best interest. Now, this one is difficult, but this is the one that actually happens in the errors and omissions issue more often than not, because attorneys forget that they're the employees, not the employers. I'm going to say that again. Attorneys forget they are the employees, not the employers. And they'll do what they want to do instead of maintaining a client's innocence. And if they do this, you then have grounds to go after their insurance and also sue them individually. And this is one of the ones that I often tell people, this is probably your best avenue if you're going to do something. Because now you can go after other things, but there's also a step-by-step guide that goes with that. It's a line-by-line, precept upon precept. And this is one of the things that most people don't actually understand or go into. Now, this is also one that I get a lot. Misrepresentation or misleading advice. Inaccurate statements of law or fact that harm a client. Now, just to give you an idea, I had a guy tell me his attorney, he's been fighting the case for over, I think, 8 months. And he goes, well, my attorney told me to sit in jail for another 6 or 7 months, and then we could file a motion to dismiss. I was like, you do realize if they file charges, they have 90 days if you file a motion for speedy trial. If they can't come forward with actual evidence against you within the 90 days, you then can file for a dismissal because they violate the speedy trial requirement. Why would he tell you to then do it, sit in jail even longer? Instead, and then I asked, did he file the motion for discovery? Did he file? Oh yeah, he filed it. So I said, here's a copy. Let me see what's on that list they got. And he goes, 90% of that stuff that was on that list he didn't have. I said, well, what's the strategy for you after you sit in jail for another few months? He goes, well, I think he's just going to file the motion to dismiss. I said, well, why not do these two instead of just waiting? What are you waiting for? And that was the question that was asked. And he didn't understand it, but he sat in jail another 6 months, and his attorney still had done nothing, but he had gotten paid. So a lot of people don't understand that attorney is now liable for giving inaccurate statements and facts that harmed the client. These things are hard to prove because most people don't get things in writing. I always tell you, any communication that you have do it in writing, because then you're forced to hold their feet to the fire. Now, defense costs is attorney fees, expert witnesses, and court costs for defending malpractice claim, even if the lawyer is not found liable. No, I want you to understand that. That is still part of the insurance claim. The attorney fees, your expert witnesses, and court costs for defending the malpractice claims. Lastly, that's something else that's done inside the claim itself. Settlements and judgments. Payment to the client up to the policy limit if the malpractice is proven. Again, there are caps that are on malpractice insurance, and each attorney has a different level. You can max those out. You can get to where a certain tier. Those things are determined by the insurance policy in which they have. So always understand that. Now, what we're going to do is basically understand the main component of this. Not every, how do you put that? Not every bad outcome is malpractice. It's malpractice when the lawyer's mistakes, not the case facts, cost you your rights or cost you money or your freedom. So sometimes, just like give you a bad fact. A lot of times what happens is once you secure counsel, let's use that. You must inform them of everything that's going on with you in order to give you the greatest defense and create a strategy for you. Now, if you fail to mention something, if you ever watch these Law and Order or any lawyer show and they're defending someone and they go, well, why didn't you tell me that? Be like, oh, that was a different case. They need to know that because there are certain things that can be used against you. And your past is one of them. Even if there's a police officer, even if it's a judge, and matter of fact, even the one judge, I believe she was she was a federal court judge. And what happened was they found out that through college, there were old pictures of her when she was a stripper or exotic dancer. Well, those exotic dancer times ruined her judgeship, so she was forced into early retirement. Not because she did anything wrong, but it is a perception of illegal activity, possibly because of the job field in which she had participated in, and which there was evidence of. Not that there was evidence of wrongdoing. So there can be certain things that can be set out that does not say, hey, this is a bad person, but it can be things that are placed out there that are non-defensible. And if you don't know, you may create the wrong strategy. And that's why I always equate this to chess. You have to make sure the board, all the pieces are seen. And if not, that can become an issue later because, again, it can change the strategy. And now, and also understand why your firm or the attorney carries malpractice insurance. It is for your protection, not for the protection of the attorney. It's for the protection of the client and risk management for the firm, because the insurance exists to protect clients who were harmed by an attorney's professional errors. And if your lawyer harmed your case, this policy is what makes you whole in some form. Like, it's not the end all be all. And one of the things that also pops up, part of claims that can be aired out, because again, I've actually wrote these in 2 different places, because I generally, whenever I'm getting my ideas together, I just start going a lot of times, and when I go, it comes out when it comes out. It's one of those things. Anyway, under the malpractice claims, a lawyer ignores court orders or discovery duties. Now, this is one of those, when you're talking about ignores discovery duties, they're not putting out a detailed discovery for your case. That is grounds for your lawsuit. Now, 2, your lawyer settles your case without your consent. This is civil or criminal, because even doing criminal, you have the right to participate in all facets of your defense, which includes any settlements or plea offers and plea agreements, which is why they have a duty to disclose any plea offers and also any settlement offers. You have a right to be part of all of that. So if a lawyer settles your case without your consent, you then can actually go after their insurance malpractice claims. A lawyer fails to raise key defenses or file motions without any competent attorney. Hold on, I actually didn't read that one. File motions any competent attorney would have. Oh, excuse me. There we go. I was like, hold on, that didn't even sound right. Anyway, again, I actually put out a video, I want to say about 3 years ago. And it was, if you have a case, do this first. And I gave you 3 motions to file at the start of any case. And it's generally any criminal case. And I think, I want to say less than 3,000 people actually watched it. And I do know some people that watched it actually still call me. So that's why I also have a means for you to contact me in the chat. I have a means for you to contact me in the description. Because the whole point is, a lot of times, most people have no idea what to file, when to file, or how to file. And that includes these low-budget defense attorneys. Again, $50,000 is that number. If you paid less than $50,000, if it was $40,000, unless that's a discount, you getting one of these trashy attorneys. And I do mean the way I just said it, because they generally don't file the things that are necessary for you to win. And that will fall under key defenses, because getting the information is job number 1. Because the prosecution has to turn it over. If you're in civil court, whoever files the complaint has to turn it over, because these are the things that are required. It is literally called discovery, so you can prepare your defense. And if they don't do that, it is a key component. That component is the foundation of everything that you're doing. So even if you're not requesting it, the prosecution has to turn it over. But in civil court, there still must be a request for it. So always understand that. And the test is, will another reasonable attorney have acted differently and protected your rights? Well, I don't like to use the word attorney. Would another learned person protect your rights in the same manner? And 90% of the time, that's no, because they don't know how to do it, because they don't know what they are. That's why people call me. This is why I'm contacted. This is why I've made myself more available to everyone. Because this is what separates being home or being in jail. Now, the biggest thing, the steps to holding your attorney accountable. Now, I'm going to say this. And it amazes me how few people actually follow it, but I'm going to say it again. And now it's on video that I'm saying it. Right? So, do everything in writing. Keep emails, letters, court filings. Make sure you have a copy of it. Make sure. Get your case file. You have the right to request it from your attorney. I'm going to say that. Make sure you have your case file because you have the right to get it from your attorney. Hell, here's your malpractice specialist. Consultations are in the in the description and also in the chat. File a malpractice lawsuit. Claims must show negligence and damages. Insurance company will step in to defend or pay. If you have all the documentation and you can show how there was, insurance company don't want to deal with it. And here's the greatest part. If the attorney doesn't have one, they are now out of code. So now you can hold them responsible or liable personally in their individual capacity, just like you would a police officer. And lastly, file a bar complaint. It doesn't pay you, but it now holds the attorney accountable. Just like whenever I spoke about, sue the police officer, sue them in their individual capacity. Also, go after their post-certification, police officers standards and training certificate. Because this stops them from bouncing from police department to the police department to the police department, which is just like one of the guys I just put up, Peter Baller. He actually he was at, I forgot where he was. Westmore, somewhere. He put somebody on the ground. He got on top of them and pistol whipped them, and he was less than a year on the job. He disappeared for a while. He got a job in Texas City, which is the same place that also held a man down and beat him for 30 minutes. I want to say a year or two prior. He then jumps on top of a man because it might be a stolen car because the registration is not in Texas. But he's now able to go somewhere else and continue working on a task force. And understanding that now, in doing this, you have short statutes of limitation for filing against their insurance claim. Generally, it's 2 years. It's just pretty much the same statute of limitations that most states have. And generally, insurance companies go by state. Lawyers argue strategic decision, not negligence. So again, knowing is half the value. This is what I teach you. What I'm showing you is what's going to be in front of you. And some of the obstacles. Difficulty proving damages. Must show loss case had merit. Now, in this, it's basically, I could have won it if, because the prosecution didn't have anything. Or because the person that was suing me didn't have anything. Insurance companies fight hard and expect a defense in most cases. Not all, most cases. Now, file early, don't wait. Focus on clear, provable mistakes, miss deadlines, fail to file, and understand my favorite part. What insurance does not cover. Now, the reason why it's my favorite part is because a lot of times we just expect certain things to be done for us or done with whatever regard that's out there. Now, intentional wrongdoing or fraud. This is thing that most people would think that there is grounds for. And that will be stealing clients' funds. That's a criminal act. That's not covered by insurance. Knowingly giving false advice, that's not covered by insurance. And again, because that is also criminal acts, which is not covered by insurance. Disciplinary action, the bar complaint, not covered by insurance. I just spoke about how the bar doesn't get you paid. Fee disputes. Now, you can actually not get the insurance to pay that. Now, this also does not mean you cannot sue them in federal court and hold them liable civilly. But fee disputes, get an itemized, and you know what? I'm giving you this for free. Get an itemized breakdown of everything that they've done that they've charged you for. Now, and this is for the people that contact me. They're going to charge you for every phone call. They're going to charge you for every email. They're going to charge you for every minute they're on the phone. It's going to be written down. It's going to be added up, because what they're trying to do is get rid of your initial fee. Whatever that is, they're trying to get rid of that initial fee. So they're going to charge you for every piece of paper, over 3 pages long. The gas that it took to go down to file it, they're going to charge you in addition to the filing fee as a service fee. But they must have that breakdown in order to charge you for it. And even if you're disputing it, you must have a copy of it, because they have to then justify it. But again, that's one of the things that you're going to need. General business risk. Now, this is not necessarily for criminal stuff, but it's definitely for employment and contract disputes, because you have the employee or employment disputes. Discrimination, harassment are not covered by that, but they are covered by employment practices liability insurance instead, not the malpractice insurance. These are things that you can apply for or can go after, but again, those are also things that are more difficult to prove unless you have those records. Now, property and data loss, covered by cyber liability or general business insurance. Those are not covered by malpractice insurance. So keep that in mind. You do have recourse, because legal malpractice insurance is not meant to cover unintentional mistakes. Is meant to cover unintentional mistakes, negligence, or oversights in providing legal services, but will not protect against intentional misconduct, fraud, or criminal behavior. All right. Now, always understand a bad reputation isn't the end of the story. Malpractice insurance exists to give you a remedy. This is to give you your security. And you have the right to hold your attorney liable or accountable. And if you were wronged by any attorney, don't just accept the loss. Understand your rights, explore malpractice claims, and remember, the law is a tool, even against those sworn to protect it. Knowledge is power, but action is justice. Don't forget, consultations are in the chat and also in the description, as well as donate to the channel to keep us going and keep us growing. And this is Supreme, and you know what it is.